SJC-12949, Commonwealth v. Cameron, Lougee. SJC-12950, Commonwealth v. Shamus, Horton. SJC-12955, Commonwealth v. Scott, Smith.
And will the attorneys on each of the cases please identify themselves with the case of Commonwealth versus Lougee first?
Shauna Stern for the Commonwealth, Your Honor.
Patrick Levin for Cameron, Lougee.
And in the case of Commonwealth versus Horton?
Catherine Semmel for the Commonwealth, Your Honor.
And Brian Anderson for Shamus, Horton, Your Honor.
And in the case of Commonwealth versus Smith?
Hi, Andrea Harrington for the Commonwealth. I'm joined by Tara Ganguly.
Okay, she's on the brief, and you'll be arguing, Ms. Harrington?
Yes, Your Honor.
Okay, and for Mr. Smith?
Good morning, Your Honors. Joseph Schneiderman for Scott Smith.
Okay, so good morning, all. Why don't I go through the protocol, which we have been using since April. I know that Clerk Keneally met with you virtually yesterday to go over it, but let's make sure all understand. We will hear first from the Commonwealth in each of the three cases. Each of you will be given 2 minutes to argue without interruption, and then following the 2 minutes, we will invite questions from each of the justices. We generally go by order of seniority, but since we keep thinking this is Justice Lank's last arguments, and then new arguments get added, but she has the prerogative to go first or last. Justice Lank, would you prefer to be asking questions first or last?
I think this time I'd like to do it first.
Okay, good. Well, it's your prerogative. We're approaching, sadly, your retirement, so you get what you want. We'll go by way of seniority. Justice Lank will be asking first. I'll be asking questions last. After I've asked whatever questions I may have, I will invite whatever justices who wish to ask follow-up questions, and then we'll proceed with regard to the next argument. Now, you've been dividing up 20 minutes per side because this is a case involving 3 separate cases, albeit with related issues, with particular distinctions among each of the 3 cases. But as a result, each of you have less time. The protocol, however, is that you may continue to answer questions as long as there are questions, but please keep the 2-minute limit with regard to the time for oral argument. If you are not speaking, please mute your phone so that we don't have any background noise. If you are not using your cell phone, please silence your cell phone so that we don't get interrupted with respect to that. And with that, we will now turn to Ms. Stern on behalf of the Commonwealth in the case of Commonwealth versus Lougee. And you have 10 minutes, Ms. Stern.
Good morning, Your Honor. Since I'm going first, my goal is to sort of focus on the issues sort of shared by all of us, the Commonwealth in this case, as well as particularly to Bristol County, just to sort of set up the background as we see it. There's 2 distinct questions here. There is, did this court standing orders that have been issued so far toll the calculation of time under 58A and 58B? And then there's the other question of course, the pandemic is still ongoing. What happens going forward? And we all take the position as laid out in our briefs that the language of the standing order tolls the time calculation of time using the mechanism of Rule 36, which has traditionally been used, as noted in Abbott A, to just directly as a mechanism for tolling 58A calculations and under the same language in 58B. And I would note that during this time, defendants have not been without an opportunity for review of their cases. You can seek review of a 58A hearing at any time for changed circumstances, for new information that has happened. It has been happening. It can continue to happen as things continue to change. So there already has been a mechanism for taking into account the current pandemic. On the issue of going forward, there's 2 different issues. There's the issue of what do we do with tolling in general, and also what are the due process considerations. Obviously, tolling only continues as long as this court continues to order it. And I think the Commonwealth's concern is that whatever happens provide tools for the Commonwealth to continue to have dangerousness taken into consideration in determining whether to continue to hold particular people up until, if warranted, we can resume jury trials. Our biggest concern is that the time not simply run out under circumstances where the only recourse is a regular bail hearing, because that cannot take into account dangerousness, that can be taken into account conditions, but things like GPS are not great tools at the moment. We think it's extremely important that we have a mechanism, whatever it is, that continues to take dangerousness into account in determining who warrants release. One way to do that is simply to keep the clock running for the purpose of 58A, but to have a due process analysis similar to that in Abbott A, with whatever adaptations this court might want, so that the defendants would have could be assessed on their particular case to have a way to get out because of the time they've been held, but without affecting sort of the bean counting under 58A and 36. Insofar as, the court has to work within the language of the 58A, 58B statute. So one thing would be to say that the time is all told, but that doesn't mean that your due process rights don't entitle you to release. And another way to handle it would be to say that the time has run out, but a good cause exception enables continuing detention on those grounds. If the court went that way, I think it would be good if the court provided guidance to lower court judges about what they do with that. I know it seems to be handled very differently from county to county, and there should be uniformity on the applicable law, while obviously case-specific determinations on how that applies to the particular cases and the particular defendants and the particular houses of correction and particular detention circumstances and particular charges, all of which go into whether a particular detention has become unreasonable. Bristol does not raise the good cause issue, so it's best addressed by my colleagues, but I wanted to throw that in there at the beginning. And again, that even if I think that really covers it, and I'll turn it over for questions.
All right, Justice Lang.
Okay, good morning.
Mm-hmm. Morning.
I am really confused. That's why I wanted to go first. So let's start with the simple stuff, which is we've got judges' orders here. Are we reviewing them on what standard? Abuse of discretion?
Bristol framed it explicitly as we just want to know whether the judge is right or wrong about whether the standing order holds the case. The other cases may have slightly different postures in terms of I believe our request of relief is simply a resolution of the law here.
Almost like a declaratory judgment, huh?
Essentially, yes. So we're not looking to get into the weeds of this particular defendant's circumstances. And we don't want the court to decide whatever the rule is going forward based on what we did or didn't raise below. We just want, we want the question answered so it can be applied to future cases. So we went with the first case out of the gate, essentially.
Okay.
So that is our position.
Okay. Now, so it's really weird to be asking how to construe our order when all of us were there and made the order. And so what is it that you're trying to get at? Our intent, or what?
I mean, I think that there are judges who are both arguing that it's obvious that the ruling does or does not hold the order, and I think that there needs to be uniformity on that. And it is obviously inherently strange to be asking this court. In theory, that ought to be a yes/no question unless this court discovers it was out of order or something, but we obviously don't think that's true. But yes, that we think should be straightforward, but I don't think it's a reasonable, it has to mean one or the other.
Yeah, but do you think the language is not clear, right? You think there's an ambiguity?
I don't think there's an ambiguity, no. But
so you think it means, well, wait a second. You think it means one thing and somebody else thinks it means another thing, so I think there's a problem there, isn't there?
Well, yes, there is, but I don't know how many people.
Are you saying? I'm sorry, I don't mean to interrupt you, but on this issue of, are you talking about plain language of the order? I don't really know how to be looking at our orders. Is it like we look at a statute when we're trying to interpret the statute?
I actually I have not found anything on that. There are defendants who have argued the interpreted the statute, but I think we treated it as in our brief as essentially a judicial finding of essentially making the findings under Rule 36B2F in a sort of global fashion, in which case I guess it would be a sort of equivalent to the finding of an individual judge on that case rather than so that essentially it's a finding of fact and a commensurate exclusion of time. There are judges below who have both considered it obvious in opposite directions that the plain language does or does not toll. We've had decisions out of Bristol County, I think, both saying that there's no other way to read this. So essentially there's a circuit split.
Okay, so let's move on because I'm still confused. But can you explain to me sort of what would ordinarily happen? And we're not in COVID-19 times, so let's just pretend that we're not in COVID-19 times. This is before. This is the pre-crisis. Okay. And what would ordinarily happen if a 58A, 58B hold expired before a trial really could begin? What would happen then?
I think that my understanding is some counties there would be a question of whether it falls under the good cause provision of 58A. I believe in Bristol County it simply gets
a hearing.
Ordered, for a hearing, yes.
I mean, so it's not automatic. It's not about an automatic release of the person. It has to be a hearing, an individualized hearing, right?
Yes.
And that's not what you want now?
The reason we don't want that now is because you cannot factor in dangerousness for the bail detention. As Judge Davis actually noted in another case, Orlando Badillo, that we took a 211-3 on after we took this case up, that essentially he had to only factor in the defendant's flight risk, and we thought the defendant was incredibly dangerous. And, that concerns us that we need to have the tools. I mean, pursuant to Bragg, you can't, for regular bail, and actually in pursuant to the language of 58A, you can't set cash bail as a way of holding a dangerous defendant.
Yeah, I get that, but I'm just saying, what's different now than it was before? I mean, somebody who was dangerous, but the time came up and it was done, and something you had to have a hearing about it. Wasn't dangerousness taken into account then?
Well, I think what's changed is that we had the ability to ensure
But you couldn't ensure that a trial was going to take place. You couldn't ensure that, right? I mean, you could always have a crisis in a place where trials are just backed up. And you could not do a trial by the time that so that there's a question of what happens to the person, what happens to the detainee. And I just was trying to figure out what happened ordinarily. You know what I'm saying?
I think in that situation we would consider it an extremely unfortunate result, but we would try very, very hard to get the time excluded for either, I think it's 36B2B, where the judge makes specific findings, or another interest of justice finding under 36B2F that we would have essentially, in this case, we considered there to be a global tolling, so we didn't seek individual determinations from judges. We could do that if we, again, insofar as we were on notice that it was necessary, we could do it on a case-by-case basis, but we would certainly...
That's what used to happen. It was a case-by-case basis, right?
Yes.
Okay. That's what I wanted to really know. And 58A and 58B both set an upper limit of some kind for pretrial detention absent good cause, and exclusive, I guess, if any continuance is granted under 36B2. But what I'm wondering is, even if we agree that the standing order operates as a continuance under 36B2F, does this bind judges to toll the expiration of a hold under 58A or 58B? In other words, does the statute require a judge to exclude such a continuance from the length of the hold, or simply allow him to do so or her to do so?
I mean, I sort of, my reading of it was that essentially, again, it was a finding of fact by a judge under the 36B2F, just sort of made at a global level. I assume, I don't know, I mean, I don't know the parameters of the ability of an individual judge to just simply disagree with that. There are, I mean, again, you can...
I mean, are there any cases you can point us to on any of these things?
I mean, this is a sort of, again,
I know, it's sui generis, isn't it?
Yeah. That's why we're all sort of here, sort of lacking, or playing around for standards of review. But I think that, I mean, again, you can revisit dangerousness altogether for changed circumstances, and that has been happening. I think that I think there have actually been some debate sort of at the lower level about the exact parameters of Rule 36 tolling in terms of when it has been specifically confirmed, but that's not, I mean, not in this situation, in sort of, in previous times. But in terms of whether a particular judge recognizes that another particular judge made the findings that judge thought they made. But but again, I think that there are parameters, for discussing,
Hard, isn't it?
yes. I mean, I agree. That's why we're here.
Yeah, I know. Okay. I know. And the order that we did with respect to speedy trials concluded that the risk of holding a trial during the pandemic somehow outweighed not only the defendant's interests, but also the public's interest in a speedy trial. But since you can hold a bail hearing by phone, how do the risks associated with the pandemic apply to the pretrial detainee? I don't really get that.
I mean, I think that, you mean just from the defendant's end as opposed to the public?
I mean, how is it, when you're holding a trial, the reason they say, you sort of tell the speedy trial thing, it seems to me implied, is because we recognize the danger of even trying to have the trial. Danger to the jurors, danger to the public, danger to the defendants, danger to everybody. But it seems to me it's different somehow with respect to pretrial detainee. All you need to do is a hearing, and you can do it by telephone, right?
I mean, so our concern is that, there are defendants, first of all, defendants being held as dangerous take priority for trial, and there are particular defendants that we think are extra dangerous that we would do absolutely everything we possibly could to make them the first trial available, but we can't do that. So our concern is we're really worried that some of these people will do very, very, so to speak, dangerous things if they get out, and we have no mechanism to hold them that takes into account their dangers. Because again, some people are flight risks and also dangerous, but I mean, you can imagine somebody who's, tells the victim, when I get out, I will kill you, I will go to the police department, I will turn myself in, I will abide by all rules.
Well, certainly all of that is true. I just wonder if there's some sort of a mechanism that couldn't be devised in which the hearing could take account of dangerousness.
That would be fine. That's our big concern.
Yeah, I know it is.
We just want something that would do that.
Yeah.
And we're essentially, we can live with anything that does that.
And including individualized hearings that do that.
We would be happy with individualized hearings.
Okay. Well, my confusion knows no limits, but I think my time is up, so I pass it on to Judge, I think it's Judge Gaziano, but Justice Gantz.
Yes, it is Justice Gaziano.
Hello. Good morning.
You're up.
Good, thank you. So, can you, two questions. Can you distinguish the GF case where, to some extent, Shamus, which were due process cases, which kind of dealt with defendants who were in limbo, and in both those instances, the court went around a statute and granted relief of those defendants. One was, the 16F statute. The other one was the no bail in SDP case statutes. And we found a due process right to review. Can you talk about those two cases, please?
So my recollection with Shamus is that there was specifically, this defendant was not going to be able to do anything. I think it was the defendant was essentially pretty thoroughly incapacitated.
Right.
So that I think that would be a crucial factor if we had anything resembling that. And certainly that would, I think that sort of defendant under, say, under a CPCS versus trial court analysis might have already gotten relief. With GF, I'm afraid I'm not recalling. I'm familiar with the case, but
GF was a person who had gone through 3 SDP trials and found.
Yeah.
And it had 3 mistrials. Yeah. And then the statute says you're not eligible for bail, but we said, well, you are, because you're basically in limbo and there's a due process right to review. Is that similar to this case?
I think that, I agree that there is a point at which you can't just be in the abstract in limbo. That's why we essentially volunteered that there should be a further due process analysis on any continued detention, that there has to be consideration for other factors, and particularly, again, there's always a spectrum of degrees of dangerousness, even, among defendants where one or more judges have found that no conditions of release.
And that's as a matter of due process?
That was our perspective on it.
Okay, so and you hit the nail on the head on my second question, and that is, what does this thing look like? this second hearing and this individualized determination. So if I'm a trial judge and I have someone who is, as I found initially, deservedly held as a danger, domestic violence case, child rape, whatever. Now, the defendant brings a motion for individualized determination. What am I looking at?
So I proposed in our brief, and I don't know whether I think different officers might have slightly different ideas here, but I think we all sort of focus significantly on the ABID-A sort of balancing of the interest procedure. Obviously, it's not directly on point because it's not. That has a lot to do with the whether the defendant will become more competent.
Right.
In this case, the defendant is fine. It's the justice system that has to sort of get itself together. Obviously, that is being worked to assiduously. How quickly it can move.
Can you give me factors? Can you give me factors that we look at?
So, I mean, the severity of the offense, let's see, where did I?
Basically, whether you're a super 58A.
I mean, essentially, somebody, we already had cases, I think we've had several cases that went up under CPCS versus trial court about the single justice, about the dangerousness where there appeared to be a line drawing, the defendant on OUI third versus the defendant who is direct physical risk to, somebody in particular. I think it would also probably take into account the conditions at the particular detention facility. They're not equal. The defendant's health are not equal. The particulars of the case, unfair prejudice to the defendant, the length of the time that the defendant is seeking, a dangerous defendant could be still facing a district court sentence where the detention period becomes disproportionate as you get closer to the length of the sentence. And how long the defendant's already been held. I think would all be factors that would have to be balanced. I know that counsel for Mr. Lougee has proposed that we should be required to demonstrate beyond a reasonable doubt that we have evidence to proceed to trial. We would take the position that holding an actual evidentiary hearing on that is sort of would be fairly burdensome when the court is already trying to get things going. But we would be happy to submit in detail in writing what we expect to prove at trial, and that we have the basis to expect that we would go forward. I would hope that that's already been shown, but show it too.
I mean, I would assume that if it's a domestic violence case, for instance, and the victim is a certain Fifth Amendment privilege or whatever the case would be, and you're not going to immunize the person, that your office would be duty bound to say, we're not going to go forward.
Yeah.
In those types of situations, correct?
Yes. So, we would think it wouldn't come to that in the first place, but we'd be happy to reassure the judge and the defendant that on the basis of our belief on that in some detail, not just, take our word for it.
Okay. Thank you, Mr. Stern. That's all the questions I have, Chief.
All right.
Justice Lougee.
Yes, Mr. Stern, good morning. I want to get into the details for a moment here of 36B2F and the standing order, OE-144. So, obviously, the position of the appellees here is that we're not dealing with, as far as excludable delay under Rule 36 for the purposes of 58A3, we're not dealing with a specific finding of a judge as it relates to a particular case and weighing for the purposes, the ends of justice with the best interest of the public and the defendant. So that's their position. What's your response to that as far as our order saying that we have this excludable delay under Rule 36, but not specifically referencing 58A?
So I think that, as a matter of previous normal time law, tolling Rule 36B tolls 58A. Again, that came up in ABID-A. Rule 36B2F doesn't specify whether it needs to be, I think, the judge whom the case is in front of, or in the case of a circumstance that affects the whole state somewhat equally, that it could not be this court. Certainly that is how the Commonwealth read the order, was and I think we've been filing things for a while asserting that we saw this as specifically the court seeking to invoke 36B2F, which then, as a matter of normal operation of law, would feed into the 58A calculation. I think my perspective has been that it's not so much that 58A, I think defendants have argued that, 58A incorporates Rule 36 because obviously you don't want the trial to get out of pace with 58A, though of course for reasons out of the control of the parties. And that's true here too, but also I always at least read, any statute that incorporates Rule 36 tolling is sort of using that for a shorthand of, we think the same factors matter here and we don't want to say it again, that Rule 36B2 is a good sort of compendium of things that we think are reasonable delays.
I understand and appreciate that. I do want to sort of ask you, though, when you look right at the text of 36B2F, it does say that the judge shall set forth in the record of the case. Does that suggest in that language a specific case as opposed to a general concept that any time under Rule 36 is excludable time from the 120 or the 180 days or the 90 days, whatever the circumstance might be?
Well, I think that, first of all, I think that issue would pertain equally to whether the standing order told Rule 36 under those circumstances. But so my reading of it had been that certainly, Rule 36 wasn't written. It was assuming in general that you would be in front of a particular judge because that is generally true, but that it wasn't intended to be prescriptive, essentially, in that language. But again, I view this court as seeking to trigger that.
I understand. Let me talk a little bit about good cause, and let's just assume that no matter how Rule 36 is reconciled with our order, there comes a day that it really doesn't matter because we're dealing with due process. And let's say that good cause is how we infuse that due process into whatever the judge is supposed to do. And I guess I want to ask you, like Justice Garciano did, what's it look like? Now, some of the appellees have referenced proof beyond a reasonable doubt, bind-over hearings, probable cause hearings that back in the day we had with some frequency. Why, and it's a tough issue once we get to the due process, what's evidentiary, what's not evidentiary, what's the issue as it relates to the law of evidence. But why wouldn't it at least be in the light most favorable to the Commonwealth that the evidence available still would satisfy proof beyond a reasonable doubt? In other words, sort of apply a probable cause bind-over hearing standard and then figure out whether or not what the evidence would have to look like at that hearing, but at least as a standard. What do you think of that?
I think we could work with that. Again, as I said earlier, my colleagues are more familiar with the good cause issue, though I don't think you're sort of probing me on the law there. I think that I think again, we're open to anything that allows us to make showings to preserve due process.
Right, because at some point it doesn't really, obviously it matters for the purpose of immediacy, how this Rule 36 issue relates to 58A3. And I'm not saying that's not an incredibly important issue, but at some point, we're going to be dealing with good cause either way, and so we do sort of have to understand what that showing would look like and what that hearing would look like. And I guess your position is, well, as you've stated to Justice Link, well, you want to know what you need to do. One last question. I don't know if you had a chance to look at Judge Coven's decision out of the Quincy District Court. It's an attachment to one of the appellee's briefs. And, as you know, he's a very an excellent and thoughtful judge. And he raises the question of whether any order of the court can take priority, overrule, whatever word you want to use, a liberty interest that's really created by statute. And the liberty interest here would be going all the way back to United States versus Salerno, that to satisfy substantive and procedural due process, there has to be a time limit, and that we have to recognize that that's what the statute was trying to accomplish in limiting the hold time. Any thoughts on his view that liberty interest created by statute can't really be deprived by a court order based on superintendence or whatever it might be?
Unfortunately, I'm not familiar enough with this decision to address it on the terms it should be. I would say that I agree that the court can't simply say, we are by fiat suspending 58A, even though let's say 58A just says 120 days and then we're done. The court doesn't have any power, I would say, to do anything with that. I think that it's the fact that it incorporates court rules and court rule tolling periods and good cause exceptions that give the tool for this court to do anything with it at all, but it already contemplates a variety of reasons why you might not be able to bring defendants to trial as quickly as you would want to, for reasons having to do with one, the other, or neither party. And I think that aspect of the statute is crucial, that it involves and ultimately a fixed date, but it very much involves an acknowledgement that things happen that up to a point justifiably cause delay that needs to be factored in.
Okay. Thank you very much. I have no further questions.
Justice Budd.
Hi, good morning.
Good morning.
I guess my first question is about our order, and I understand you to be saying that you think the plain language of our order does apply to people held under 58A, but isn't it a fairer reading to say we just overlooked this?
Well, I admit that my reading was influenced by the previous law of essentially that I'm accustomed to view any 36B2 tolling period as automatically feeding into 58A under the explicit language of 58A. So I did think it followed. We took this issue has been litigated a lot, and I think the Commonwealth took up essentially the first set of adverse decisions, so there were a variety of courts that did take that view of it for about 6 weeks. Obviously there's not unanimity, and obviously that doesn't affect what this court meant, but that I think that we're not nearly alone in taking the perspective that we thought it was clear that was what it meant.
Mm-hmm. And I'm struggling with the due process issue because it sounds like that is what we're coming down to.
I agree,
and I'm good. So I'm curious to know what the Commonwealth's position is on where those due process limits are. At what point do you say this isn't right?
Well, again, we argued in tracking with Abbott A that essentially it has to be somewhat fact specific, but the court said in Abbott A there's a point where the Commonwealth will be required to show dangerousness beyond a reasonable doubt, and in order to justify a preventive detention. When you hit those points is inherently very, I think, hard to say, unfortunately, by the nature of due process analysis. And I wouldn't argue for any particular date, including, either sooner or later. I recognize that's sort of dumping it on the court, but I don't know that I have anything useful to offer in terms of exactly when you hit that trigger.
Okay, but earlier I think you said that there were factors that judges might look to other than dangerousness. I thought I heard you say that it might be depending on specific, whether they're incapacitated, obviously that's dangerousness, but the specificity of the risk, how long they've been held, what kind of, what the conditions are of the facility they're being held in, those types of things. So are you saying that that the judge who's holding the hearing should be looking to factors outside of dangerousness, or no, given the fact that they're there because of their dangerousness?
I think that once a due process analysis kicks in, you will consider all of those factors. You don't necessarily reach proof beyond a reasonable doubt. Initially, again, as with Abede, you start with sort of weighing the factors. As often, I know that my opposing counsel suggests a review every 30 days. I think our position would be that the defendant is entitled to ask for a review whenever he thinks there are new circumstances, and that might be more useful than having sort of tightly time-dependent automatic reviews, but that's ultimately a practical matter. But that essentially, again, as with Abede, you would start with, first of all, you accommodate the requirements of things that are told under 36B2. They didn't seem to consider that to be optional in Abede, but then due process has its own requirements, absolutely independent of Rule 36 and of 58A, where detention becomes too long. Then you weigh those factors, and then if it goes on long enough, you might be required to go to a showing beyond a reasonable doubt. I would also say that in terms of factoring in essentially the competency of the court, in this case, it is possible that the different courts will end up being able to reopen and restart. Again, jury trials, nobody knows at this point, I don't think. But I know that we've started running the grand jury again on a limited basis. I know other counties have not been able to. So there may well be ultimately fact-specific determinations about how quickly particular defendants in particular parts of the state are likely to be able to go to trial, and what role either the defendant or the Commonwealth has been playing in encouraging or delaying that.
Okay, thank you.
Justice Seifer.
Thank you. Good morning.
Good morning.
One question. This question might not really be within, maybe should be directed to a different counsel, but do you think the rules should end up being, or the results should end up being the same under 58A and 58B, or are they just totally different?
I don't have any reason to think they should be different. I think Berkshire may be able to suggest some reasons they should be different, but I think that insofar as our focus is on interpreting the language, I mean, in terms of due process, there may well be reasons why they should be different that I wouldn't necessarily be qualified to answer, but in terms of, the question of what has happened so far, I think they're similar.
All right. And then my other question is, if we assume for the sake of argument that there's no end in sight to the situation we're in with the COVID-19 pandemic, and if we assume that you're in a position where certain people are going to be held under 58A because of dangerousness, and ultimately you may reach the moment where due process requires you to prove dangerousness beyond a reasonable doubt. At that point, I'm wondering, is there a mechanism, or do you see it to be possible to petition for us, perhaps, to order an exception to the no trial order?
Oh, you mean to try that particular defendant?
Yes.
I think that the standing orders already provide, at least for a bench trial, to hold an exceptional trial. I don't know what would be involved in holding an exceptional jury trial, just given the human logistics of that. I suspect it would vary from court to court, but I don't think if there's any factual basis that would permit doing it safely, I would be on board with being able to petition to do it safely in particular cases by whatever process. I believe we're ready for trial in many of these cases.
Well, that's what my assumption is, that if you can reach the stage of proving dangerousness beyond a reasonable doubt, you're pretty close to proving your case, I would assume.
Yeah. We're ready
in most circumstances anyway. Right.
And then this is just a more broad historical question that really may not be an answer to, given the nature of what we're dealing with. Is there any kind of situation that we can turn to historically to compare how trials were handled in a vast disaster or civil war or anything?
Yeah. I don't immediately know of any. I could look into it. The constitutional provision, the practical application of the Constitution has changed so significantly in the past 60 years that I suspect there would be differences in how it was handled, though I don't know that they would be dispositive.
So technology just changes everything, and everybody communicate, and this moving so fast because of international global travel that I can't imagine we've done anything similar. I just wondered. Thank you. I don't mean to be further.
Justice Kemp.
Thank you, Your Honor.
So my questions relate. It looks like you're comfortable with the beyond. Once the time limit is expired, you're comfortable with the beyond a reasonable doubt standard, correct? For proof of dangerousness.
It wouldn't be our first choice, but we would certainly. Yeah.
Your colleagues have not conceded that, from what I gathered so far. What else do you have to prove? I'm just trying, to imagine a situation. Maybe we have a resurgence of COVID. This keeps going. What else do you have, and we're now well beyond the time limits, 180 days beyond the time limits. What else do you have to prove anything else beyond dangerousness, beyond a reasonable doubt? Do you have to get into the substance of your case and satisfy burdens of proof on that?
I would argue in favor, I think I stated earlier, we would have no problem making paper showings on that in some detail. We would be reluctant to volunteer ourselves, so obviously what's necessary is necessary for full evidentiary hearings, at which point essentially you're holding a two-tiered system bench trial before a jury trial, and that's just a lot going on when we're trying to move things. But I assume it would be theoretically possible if it were required. We'd certainly be open to making again, demonstrating that we are in full good faith, prepared and able, and expect to be able to bring the defendant to trial on specified evidence.
So, and the beyond a reasonable doubt standard on dangerousness, I take it you're relying on Abbott, right? For that? Yes. Where does Abbott get that? Is that just pulled out of, where does that come from? Because it's a significant departure, right, from, I just don't know where it comes from.
Yeah. So my reading of Abbott is that Abbott gets it by analogy with other predictive detention, which is largely SDP, and possibly also civil commitment of, I don't know if he
draws on the SDP stuff to get, okay. All right, that's all I have. Thank you. Mm-hmm. Thank you. Mm-hmm.
All right.
All right. Well, since I wrote Abbott, it comes from the civil commitment obligation of proof beyond a reasonable doubt. What Abbott says is that at some point you may need to seek a civil commitment where the standard is proof beyond a reasonable doubt. Isn't that what Abbott says?
That is my understanding.
Okay, but it was in the context of doing a civil commitment proceeding as an alternative.
That is true.
It was not set up as a separate criminal hearing. It was said at some point you may need to civilly commit the person as opposed to holding that person awaiting a criminal trial indefinitely. Correct?
Obviously, your understanding governs. I thought it was potentially instructive on the issue of what is sufficient process under circumstances.
I look back to it. There's a comma. I understand that whether the comma is viewed to be a separate as opposed to being parcel of a civil commitment hearing. So I do understand. Understand that it could have been read that way, but it wasn't how I wrote it. But
all right.
One question. You've been burdened with many questions. So let's play this out. We have said that we are going to be hoping, perhaps, to be beginning jury trials in September, and maybe only be jury of 6 initially. But at some point, we do expect to once again have jury trials, and then the SJC order continuing all jury trials will end. is it fair to say that at that time, once the SJC order ends, then any further continuances would have to be governed by the individual judge with regard to 36-2F?
I think so. I think that, obviously we want to make sure there is not a situation where 58A for everybody runs out. We can only try some subset of people immediately, and we can try other people immediately plus one. That there has to be some way for taking into consideration the need to do that. But yes, that ultimately I think the regular proceedings of trial by one way or another would govern.
So it appears in terms of the issue, the due process issue applies only as long as there is no speedy trial exclusion. Correct? If there's a speedy trial exclusion, the good cause kicks in only when there's no longer any speedy trial exclusion.
With the caveat that I'm not the authority on good cause among the litigants, I agree.
Right. So the issue really comes what happens if the delay arising from the excludable periods under 36 are so long that those periods themselves trigger a potential due process issue. Is that your understanding?
I think so. I think it's sort of an either or, that either we have tolling from this court's finding of justifiable delay and that exists on its own, or the time runs out and we do the good cause analysis.
And now, looking at the due process analysis, here's one concern I have, and I don't know how you would evaluate it. I'm always concerned about situations in which a defendant, in a case in which the person is not likely to get a substantial sentence, is faced with the dilemma of saying you can walk out today with a time served, or you can insist upon your right to trial, because after all, you might be innocent, but that will substantially delay, that will prolong your detention. Would it be a situation in which a due process concern would kick in?
You mean as time goes on, or immediately, if that happened today?
Well, I'm talking about cases, mostly district court cases, opposed to superior court cases, in which a judge can say, really, the sentence I would impose for this case, even if you be found guilty, is going to be no more than what you've already served. So if you were to plead out, I would accept a time served. Does that then generate a due process concern for prolonging the period of detention?
I think that would certainly be one of the things I would think most likely to be a clear factor in any due process analysis, which again we foresee being necessary going forward. That would, the question of what sentence the defendant faces if convicted, it's not analogous to incompetency where you can't hold somebody for more than half the time they would have served. But it's the general principle, the equitable principle underneath it, I think would certainly hold true, and that would be a major factor for judges to consider.
Okay. I have no further questions. Any other questions of any of the justices? And hearing none, we'll turn to Ms. Stemmel in the case of Commonwealth versus Horton. And Ms. Stemmel, you have 2 minutes to introduce your arguments and 5 minutes in theory in total, or until questions end, which may be less than the 45 minutes that we had for questioning from Ms. Stern. So you may proceed, Ms. Stemmel.
Good morning. May it please the Court, Catherine Stemmel for the Commonwealth. I join in the arguments advanced by my colleagues here and by Norfolk in their amicus letter, but I'd like to focus a little bit on the good cause issue. The exception for good cause contained in 58A and B is not defined, but it's been commonly understood and used in context of excusable delay, circumstances that are beyond the control of the parties or notwithstanding their diligent efforts. In this COVID crisis, which has closed our courts to non-emergency business and frankly paralyzed our country and affected all pretrial detainees in a similar manner, is a clear example of this. In CPCS-1, the court found changed circumstances for pretrial detainees as a matter of law due to the COVID crisis, and the Commonwealth urges the court to make a similar finding with regard to good cause for the across-the-board trial delays that have been occasioned. It also bears repeating that a specific avenue for release for pretrial detainees was established by this court in CPCS-1. In ethics alone, more than 270 petitions for release under CPCS-1 have been heard in the juvenile and district courts. 72 of those were allowed, and 50 of those who were denied were then heard on 211-3 review by the very hardworking single justice. Importantly, that process under CPCS includes considerations of public safety and a defendant's dangerousness, which has been already noted. A bail hearing specifically does not. And I would just note a particular concern raised by the defendant in my case, who has been indicted as a youthful offender. There's no question we will all agree that the juvenile justice system is designed not to punish, but to treat and rehabilitate. But the defense allusion to dead time in that system is a misnomer. Even if a DYS commitment results, consideration of time spent in custody, pretrial, and treatment in progress during that time is considered in the DYS classification process. And while I'm not an expert on that point, I would refer the court to a brief that was just filed in this court by the Department of Youth Services in Commonwealth versus Lopez and Terrell, 1295515 and 16, which specifically discusses the concept of dead time and refutes it. And I would suggest that nothing in the analysis in this case as to the tolling issue or the good cause issues under 58A and B should differ for juveniles or youthful offenders. But I would be happy to entertain any questions this court has.
All right, Justice Lang.
Yes, good morning. I guess I'd like to pick up where you left off. Why shouldn't it be different for juveniles?
I think that the tolling issues and the good cause issues strike the same across adults and juveniles. I do think that if this court were to reach the point of creating a due process analysis and recognizing that at some point, despite the permissible detentions under the law, that due process considerations have been implicated, then certainly at that point, the juvenile status is a valid consideration in the totality of the circumstances. But otherwise, I would disagree that there's any good cause for treating them differently when reviewing whether or not the detentions and the delays occasioned by the COVID crisis are valid.
What tools would be available to defendant juveniles to challenge continued detention if the standing order language applies?
The juveniles have and can file motions for presumptive or non-presumptive release, which are being heard, across the Commonwealth. Juveniles can, like other individuals, can petition for exceptions to the no trials, being the general no trial rule right now, to have their cases heard. But really, the idea that juveniles might be tempted to plead a case is really less applicable when we're talking about juvenile commitment, because juvenile commitment is to a certain age rather than a determinate period of time. So there's no clear benefit to push a juvenile towards trial or plea, even more so than for an adult individual. And certainly the purpose of the DYS commitment is to rehabilitate, is to provide schooling, is to provide access to counseling, and it's not punishment. And I think that's an important consideration for juveniles.
So tell me, what is it you think we should do?
Well, we certainly would love the court to clarify its position with regard to 58A in the standing order, and it's our belief. But of course, we're in the funny position of telling the court what we believe the court
meant. Yeah.
It's our belief that is a logical conclusion of the court's standing order, whether, as with all drafters, whether the court had it specifically in mind or not, we would ask the court to clarify that is in fact the effect, as many lower court judges have found. Would certainly like the court to find that the COVID delays constitute good cause for delays of the trial. They strike across the board with all defendants, and it would be helpful for this court to make a pronouncement in that regard, as it did for pretrial detainees with regard to changed circumstances. And I think our office, in conjunction with the other offices who are arguing here today, recognize that because there is no clear end in sight, even though we seem to be moving in a good direction, that it would be appropriate for the court to recognize that at some point a due process violation claim might be brought by an individual who is incarcerated, and that at that point there should be a totality of the circumstances analysis to assess whether the detention is so severe that due process violations have occurred. But I do think it is important to note, as I think you noted, Justice Lank, that, what typically happens? I mean, it is not atypical for the 120 or 180 days to be exceeded for any number of reasons, for excludable delays by the defense, for good cause related to matters of evidence and witnesses. So this is not a unique circumstance so far as the idea is that trial does not happen within the time period specified. But I think it is appropriate for the court to recognize that at some point the delays may be so extended because of closures or the log jams created by closures that a due process claim could be heard by the court and advanced by a particular detainee.
Okay, well, let me just make it simple for myself. Now, if there were to be in the ordinary times, pre-COVID times, let's talk about ordinary times, usual times, what would ordinarily happen in a 58A, 58B situation in which the hold expired before the trial could begin? What kind of a hearing would be held? And you were saying it would not include dangerousness; it would just be one regarding bail. Is that the key distinction?
Well, in this case, for instance, in the Horton case, what happened was that the defendant was held on dangerousness grounds for 120 days. On the 120th day, the case was scheduled for hearing. At that time, the parties argued whether or not a bail hearing should occur. The Commonwealth argued that the tolling provisions of 58A applied, so that from the time of March 17th until the day of the hearing on May 4th, the time under 58A was essentially excluded. She also argued that the defendant hadn't objected to delays. The Commonwealth can argue for excluded time at that point. And so at that point, the judge would typically make a determination whether or not the time has really expired when you take into account excludable delays.
Okay, well, let's say the court said, okay, the time is really up. Now what? Now what happens?
Then the court would, as it did in this case, have a bail hearing for the defendant.
And the bail hearing does not take into account dangerousness.
Correct, which is
that's really the nub of it, isn't it?
I'm sorry.
That's the nub of it. That's really the gist. That's the gist of what you're arguing is that there's no place to take into account continued dangerousness.
It is the impetus, certainly for our belief that 58A should continue to apply. Yes.
No. Okay. Let me ask you a question, but at an individualized hearing, right?
Yes, Your Honor.
Okay. Let me ask you a final question, which is one that I asked before of Ms. Stern. She was basically looking for a declaratory judgment. Is that what you're really looking for? Are you looking for relief with regard to Horton in particular?
In the sense that, the Commonwealth is asking for a legal interpretation of the standing order and clarification, and the Commonwealth is asking for a determination of good cause, which can be applied by the lower courts. So if that is a declaratory judgment, which I have to say I'm not sure, but then yes, the Commonwealth is asking for that.
Mm-hmm. Okay. All right. Thanks. I'm done.
Justice Graziano.
Thank you. Just So I think you agree with Ms. Stern that we're all used to excludable delay, that DNA testing is going on, et cetera, and we're used to excludable delay applying Rule 36. But here, I think you agree with Ms. Stern that at some point there reaches a due process overlay, correct?
Correct. Yes, I do.
And certainly, if ever there was excludable delay, the COVID crisis would be it. So now, when we get to the due process overlay, and you discuss the totality of circumstances test, can you give me some instances or some factors a judge would have to look at in that totality of circumstances?
Certainly, and you're going to find them somewhat repetitive, I have a feeling, but I think they would include the length of the pretrial detention, the degree of dangerousness, the seriousness of the offense that has been charged, any unfair prejudice to the defendant. It may also take into account the strength of the Commonwealth's case, although I would say not with any inflated standard of proof, such as is suggested by the defense, but just as one factor that the court may consider. And really to take, there is no set time for that an individual can be held, and there's no set circumstances, but I think those are typical circumstances the court might consider.
Okay, thank you. And then just final question. Mechanically speaking, all these cases would occur at the end of the time period, right? So when is this triggered, this due process overlay, this review?
I'm not exactly sure. I don't. I don't think that. I really think it depends on the individual case, and I think that if the court establishes parameters, then an individual may bring a claim of due process violation, just as a defendant, a detainee, can bring a claim for presumptive relief for release as a pretrial detainee once.
Because you would assume it would be malpractice for any defense attorney not to bring a due process review claim the day after the time ends, right? Well,
I wouldn't, because because the circumstances of the case, when you're arguing I'm one day beyond 120, or I'm a month beyond 120, I mean the enormity of the detentions that are discussed in cases that the court mentioned, such as in GF, where I believe the defendant was held for 7 years, suggests that it's just not a due process violation for an individual to be held, as they commonly are for short periods following detention.
Right. I guess that's where the rubber meets the road as far as, what are the factors and then when is it triggered? Should we set a time limit on when it's triggered?
I mean, the court could certainly set a time limit for after the tolling period is completed, but I'm concerned that it would send the wrong message.
No, I mean, I think you suggested it's not the day after, but should we set a time limit, 30 days, 60 days, 90 days?
Well, certainly, I mean, the outer limit would seem to be, the speedy trial right to be brought to trial within a year. So if the court set a limit, such as 60 days or 90 days beyond the tolling period, it could certainly do that in a way to provide some guidance, and not have just a flood of motions brought, as we've certainly seen, with presumptive release motions. And I have to say I hadn't considered it, but I do think that if the court set a minimum threshold, that might be helpful.
Thank you. That's all the questions I have, Chief.
Justice Lougee.
Thank you, Chief. Good morning, Ms. Simmel.
Good morning.
Let me just make sure I understand your view of good cause in the statute under 58A3. So we've read a lot in the briefs, and we've asked questions about the relationship between our order and 36B2F. But I think your position is that where the statute says, but in the absence of good cause, the person shall be detained, that you're saying that good cause is for those circumstances when there's a reason to continue to hold somebody, but the excludable delay under Rule 36 has no longer assisted in keeping the person held, whether it be 120 days, 180 days, or 90 days. Is that right?
Correct.
Okay. And then you agree that, again, we're all struggling, but there comes a point in time where we have a potential due process issue, and you've answered Justice Gaziano's question about the totality of the circumstances, and it's a really difficult, thorny issue as to when it is. But let's assume, for the purpose of my question, we're at the when. And the question is, what's the hearing look like? What does due process require under the United States Constitution, under United States versus Solano, and under Mendoza? What does due process look like when we reach that point? What's the hearing look like?
I don't think the hearing itself is so very different from, a 58A hearing, from a bail hearing, where the parties submit information. The Commonwealth can submit, information about the offense to show the strength of its case.
But I'm sorry to interrupt you, but a 58A hearing looks a lot different than a bail hearing under 58.
Yes. Well, I think that a due process hearing can be conducted on the papers for the most part, with it primarily, it would seem, concerns information, factual information. How long has the person been detained? What's the nature of the offense? What are the nature of the Commonwealth's proofs? Did somebody sell drugs to an undercover officer? Or is it a much more difficult case to prove? All of these factors can be introduced, and I don't think that it probably needs to be evidentiary. I think that it could be done based on the assertions of counsel.
Okay. And lastly, as far as Abbott A goes, it doesn't seem that the points there are very important, but it doesn't seem that Abbott A really works as a doctrinal framework here. Do you agree with that? I mean, the principle is important, but trying to chisel in progress being made and reasonable period and all of that into COVID-19 from an issue of competency, it's a lot of chiseling to fit that in as a doctrine. Do you agree or disagree with that?
I agree that some parts of it don't fit as well as others, but I do think that the basic components of a due process claim that I mentioned are mentioned similarly in Abbott A, and I think they're just general due process considerations with regard to detention. So yes, I agree that it doesn't fit perfectly, but that some helpful guidance can be extracted from it.
Thank you very much. That's all I have.
Justice Budd.
Hi, good morning. I was wondering if you see the juvenile court standing order as speaking at all to the tolling of the time that a juvenile spent detained under 58A.
I don't think I do, no. And I believe the defendant in our case talked about the possibility of holding bail hearings, which, is certainly true and valid, but I'm not sure how anything in the standing order, I'm not aware of anything that specifically affects this issue.
Well, when you say that the court can hold bail hearings, but you're saying not until the excludable time has expired, is that right?
Correct. Correct. I think that I was confused by an argument made in the defense brief, which seems to focus on the fact that bail hearings can be held, which the Commonwealth doesn't contest the capability of holding hearings on any of these points, but just the propriety of it.
Okay. Okay. Thank you.
Justice Safer.
I have no questions. Thank you.
Justice Kafker.
Your colleague, Ms. Stern, suggests that we should incorporate the beyond a reasonable doubt standard for dangerousness in the due process part of the analysis. Do you agree with that?
I don't think it's necessary. I think that the typical showing of dangerousness is appropriate, particularly when you're taking into account all of the other considerations that surround it. And I think in general that it is more helpful for the court to provide a list of factors the lower courts can consider and should consider in assessing this issue than to set up any inflated or standards of proof for any one party, whether it's proof beyond a reasonable doubt of dangerousness or facts of the case. I think that the due process analysis is satisfied by merely taking into account all of these factors under.
I'm just confused though. If we've got someone, we're well past. We've gone through the excludable delays. We're well over the 180 days. We're holding someone. Don't we need
now
to raise
exiting
that
Shamus Stern?
Don't we need to raise that standard somehow? Because otherwise, it's just the same. I mean, there's no consequence of this going on indefinitely.
Well, I think that the question is really, is the defendant being held too long? And that seems to me the crux and the difference when you're viewing it months and months down the road, or however far down the road. Is this too long under the circumstances? And dangerousness is a factor, and all of these other things are factors, but I'm not sure that upping the ante of one particular factor is serving the purpose, because it seems to me the crux will always be, like, is this just too long in the totality of the circumstances? And I think that that's what changes, and that's what can create a due process issue.
My other question is, we treat juveniles differently. When we write this opinion, is the juvenile due process discussion the exact same as the adult due process discussion? Or is there a difference here that you're recommending?
I think that the only difference is that the court would, of course, take into account the fact that he is a juvenile. The fact, any circumstances he might want to raise about his detention would be valid considerations, I'm sure. But I don't think the process is different. And I think there are things
Could you explain that a little more? Because, a juvenile is less vulnerable to COVID than an adult usually. So, is that cutting against the juvenile? I'm just trying to understand, what is juvenile? How do we take into account juvenile status in this?
The science on COVID is evolving and changing so rapidly that I would not make any pronouncements about whether juveniles are less susceptible to COVID. I've washed my groceries.
Now joining
Shamus Stern. So and I think certainly there's been a surge of juvenile cases, particularly in New York for COVID. So I would not rely on.
But again, I just don't get. I'm just trying to. We've got a juvenile case. Our juvenile justice system is very different. But I'm just trying to understand. It basically, I'm not sure it's helpful just to say that he's a juvenile and that's the difference. I'm trying to understand, what do we do with that difference?
I would just say that I don't think any of the circumstances pointed out in the defendant's brief are valid reasons for treating a juvenile differently. And I can't say that I have any of my own, except for the general considerations we have, in determining whether it is compatible with the goals of our courts to treat and rehabilitate youth. And if for some reason we feel like that's not being achieved in the juvenile setting, in a committed setting, then I think there can be considerations about that. And I don't know how to quantify the difference, except to say that we do often take into account the age of offenders, the circumstances of their detention, and if to any extent they are different for the juvenile, then I think those are factors that he could raise.
Thank you. That's all I have.
This is Gant. I have, I think, only one question. We have had, over the course of time, many cases in which there's been excludable delay under Rule 36 that's gone well beyond 120 or 180 days. We've had key witnesses who have been ill. We've had counsel who've been ill. We've had motions to suppress, which have been complicated and taken a long time to resolve. Have we ever said that you can move for a due process hearing when there has been excludable delay that has extended the 120 or 180 days?
I'm not aware. No, in that circumstance, no, I'm not aware of any such case.
So what makes this form of delay, which is, depending on what happens in September, in the ballpark of 6 months, what makes this period of delay so unique as opposed to other forms of delay that are excluded under Rule 36, whether it be because of illness or the inability to locate a witness or because of the resolution of a complex set of pretrial motions?
It might be, in this case, the indefiniteness of it. Now, the court's orders are not indefinite by any means, but we all understand as the orders have been reissued and that it is unclear exactly when it will end. And for that reason, I think the Commonwealth understands that at some point, which, as we advocate in our brief, we don't think we're at by any means, there may be due process concerns, even though that's because of just the complete inability of the Commonwealth to bring a defendant to trial. And while that satisfies the statutes, I believe, the statutes in the court rules, it's possible that a defendant could bring a claim in a particular case that it is unreasonable and violates due process, and we recognize that possibility, and for that reason we understand that the court may also want to recognize and provide parameters for the lower court, or it may find that it's premature to do so. But it is certainly something that I'm sure we're all thinking about, just due to the indefinite nature of the current crisis.
Okay, I have no further questions. Are there any further questions of the justices? And hearing none, we'll turn to District Attorney Harrington in the case of Commonwealth versus Smith. Scott Smith.
May it please the Court, District Attorney Andrea Harrington for the Commonwealth. I am here today asking this Court for a process for trial judges to follow, because the inflexible application of the pretrial detention time limit as applied in this particular case will result in the pretrial release of individuals who pose significant risks to my community. For example, there is an individual who is currently held pursuant to 58A and charged with assault and battery with intent to murder arising from his attack on his wife with a hammer. The victim tragically died from her injuries many weeks after the initial attack, and so the Commonwealth is waiting for the ME's report in order to seek a murder indictment. Based on the logic used in the Smith case, the trial court would release this individual once his 180-day detention period is up just because the clock had expired. This inflexible approach in the Scott Smith case is in keeping with local court practice here in Berkshire County, and it's inconsistent with the legislative intent of the detention statutes pre or post-COVID. And I also want to make clear that I do not in any way support indefinite detention. What I do argue is that the combined language of the statutes, Rule 36, and this court's standing orders result in excluded time up to this point and allow for excludable time based on good cause and Abbott A. I also would like to point out to the court that a more flexible approach incentivizes individuals who are currently detained to agree to helpful conditions of release in the event that, the Commonwealth can come up with those kinds of agreements in lieu of proceeding forward to push for their further detention. I would also like to address some of the other questions that have arisen and some of the points that were made in the defendant's brief. We are really asking for a process here, and the process to me would preferably be a process where, the Commonwealth bears the burden of proof. The burden of proof is a clear and convincing evidence standard. I do not believe that we would be able to meet the burden of beyond a reasonable doubt when we're trying to argue that there are no conditions of release that would protect the public, because it would be requiring us to predict future behavior based on past instances. That would be similar to an SDP case, which requires an expert opinion. I think that is an impossible standard to meet in these circumstances. And I also would like to say that I believe that requiring an evidentiary hearing to determine good cause under 58A would create a strain on the already burdened trial courts, and I don't think that it's feasible, nor is it consistent with the statutes as currently written. And so with that, I will take any questions that you may have.
Okay, Justice Link.
Well, are you asking for something different than your colleagues?
Well, to the extent that we really would prefer not to have the burden beyond a reasonable doubt, I don't think that we can meet that. And otherwise, I would say that the difference is I believe that the court standing orders indicate that you intended to decouple the clock stopping on detention hearings from speedy trial. I think that the language at paragraph 13 in your order sort of indicated that. I think speedy trial is a very different determination than how long people can be held pre-trial. So I think, we would be comfortable with the court saying that the clock stops as of this opinion or whatever date that you choose, and going forward on some kind of process that considers due process.
Okay. I don't have anything else. Thank you.
Justice Gaziano.
Just one question. And you've got a defendant who's accused of domestic violence in a very serious case, who has compelling dangerousness issues. But where is that tipping point where we go beyond excludable delay and we start looking at due process considerations? What do we say in our opinion when that is reached?
Well, and I think Justice Gantz alluded to this when you have defendants that are being held pre-trial and they are, approaching maybe half of the time that they would have to serve were they to be found guilty, or further than that. So, that point is well taken.
That's section 16F. What we do in competency cases, right? You want us to borrow from that?
I mean, to me, I looked at that as potentially a guide.
Okay. All right. I have no further questions. Thank you.
Justice Lougee.
Yes, thank you, District Attorney Harrington. What about the argument that some of the appellants have made here about in our order reference to the deadline in OE 144? What are your thoughts on that?
So, in the initial order that the court put out, to me, I took that to mean that you were trying to create a catch-all provision that would maybe contemplate a lot of different circumstances, and it was my understanding, and other judges, Judge Hogan in a Superior Court case, came to the same conclusion that paragraph, I believe it's paragraph 12, applied to these particular deadlines that we're talking about here. That's how I read it. That's what I...
Now exiting.
Joshua Werner.
Right. And I think the appellee's position is that use of deadline in Section 12 refers only to procedural deadline. Why do you think that might not be right?
Well, I think that this court does have more latitude in interpreting its own rules of court than it would in a statute. There's also a footnote 11 from Commonwealth v. Perkins that I think is relevant. It says the issues raised here are significant to the operation of the criminal justice system. We decline to apply a strict waiver rule in this instance, and we consider the merits of the Commonwealth's argument. So I think that could potentially be instructive.
All right. One last...
Now joining.
Joshua Werner.
One last area. So we're sort of struggling with Rule 36 and when's the point at which we're dealing with a constitutional issue and a due process issue. Are we looking in the wrong place when we're talking about Rule 36 to try and figure out what this point is? Aren't we really talking about an issue that's approaching the concern of constitutional right to a speedy trial and perhaps the factors that the court might consider under Barker versus Wingo as far as trying to understand when that point is, as opposed to a presumptive particular date?
Well, Your Honor, I would definitely argue that there's a strong distinction between speedy trial where people are not detained pre-trial and people who are being detained pre-trial. And other than that, then, I think that perhaps I would agree with you on that.
Mm-hmm. Okay. Thank you very much.
Thank you. Hi, good morning. My question for you is, assuming that the standing order does apply to detention due to dangerousness, if we look at 36B2F, it requires specific findings in a particular case, right, to qualify as a period of excludable delay. And so I'm wondering if our standing order meets the requirements of 36B2F, where we just sort of blanketly say that the time is that there's it should be excluded for the interest of justice and whatnot.
Well, Justice Bud, I believe that because of your supervisory powers over the court, that you have the authority to change the deadlines of 36B2F with your standing order.
Okay. All right. Thank you.
Justice Seifer.
I have no questions. Thank you.
Justice Kafker.
No further questions. Thank you.
And I have no questions. Are there any questions of counsel? I'm sorry, any questions of the other justices to District Attorney Herring? And hearing none, thank you. And now having heard from each of the three prosecutors, we'll now turn to the defense side. And Mr. Levin, you are first up in the case of the Commonwealth versus Cameron Lougee.
Thank you, Mr. Chief Justice. May it please the Court, Patrick Levin on behalf of Cameron Lougee. I will address issues common to the three cases. Attorney Anderson for Mr. Horton will focus mainly on issues specific to the juvenile court. And then Attorney Schneiderman for Mr. Smith will talk about the specific issues that arise in the context of bail revocations, where there hasn't been a finding of dangerousness at the outset of the case. The Commonwealth has presented this case as a choice between imprisoning everyone
now exiting
Brian Anderson bail until the pandemic is over, or letting them all out to roam the streets at will. But as Mr. Lougee himself demonstrates, that's a false choice. The reason why is simple. People don't just walk out of jail when their 58-day detention expires. Instead, they get a bail hearing. Bail is our Commonwealth's time-honored method of dealing with people accused of crimes, and our bail statutes give judges discretion and flexibility, including the ability to impose conditions of release and, even where appropriate, de facto orders of detention, as occurred in Mr. Lougee's case. Section 58A is a rare exception to a usually unflagging principle. People who have been convicted of no crime may not be imprisoned by the state. This court upheld that exception 25 years ago only because the length of detention was strictly limited to 90 days. But the statute now permits presumptively innocent people to be imprisoned for potentially up to 300 days before they can seek admission to bail. Assuming that longer duration remains permissible under the Declaration of Rights, it
name not recorded.
It surely approaches the outer bounds of acceptable incarceration for presumptively innocent people. And locking those people in congregate settings where they can't defend themselves from the pandemic presents a serious constitutional question of its own. Our argument today is simple. This court should respect the legislature's judgment about the point at which preventive pretrial detention generally becomes unreasonable. Once that point is reached, a bail hearing should be conducted, unless the Commonwealth moves to extend the length of detention for good cause. Any other construction of the statute would deprive pretrial detainees of liberty without due process in violation of the 14th Amendment and Article 12, and of their unalienable rights to defend their lives, seek their safety, and be protected by society under Articles 1 and 10. Finally, if the Commonwealth does move for an extension, an evidentiary hearing should be held to determine whether good cause exists to deny that defendant an opportunity to seek bail. And in light of the constitutional concerns raised by incarceration during a pandemic without any prospect for a speedy trial, due process requires a judge to subject the Commonwealth's case to meaningful scrutiny before extending preventive detention beyond the duration contemplated by the legislature. Specifically, good cause for indefinite detention during a pandemic only exists if the Commonwealth is able to demonstrate beyond a reasonable doubt that no conditions of release could suffice to protect the public, and that they possess sufficient admissible evidence to get the case to a jury when trials resume. I thank the court for its attention. I'm open to questions.
Justice Frank. Justice Frank, you will need to unmute.
You're right, I did. I'm sorry. Good afternoon. Good morning. I wanted to talk about the hearing, the good cause hearing that you're talking about. I take it at that time in which dangerousness could be considered?
Yes, that's exactly right. Dangerousness would be certainly a relevant factor at the good cause hearing, and it would just need to be proved beyond a reasonable doubt.
Where do you get the beyond a reasonable doubt from? I mean, that's not in the statute, is it? Not in 58 days. That's not what was said. Let me put it another way. That was not the standard that the Commonwealth had to meet the first time around in proving dangerousness, is it?
That's correct. And the only reason that a lower standard was acceptable under the Declaration of Rights, according to Commonwealth versus Mendoza, was the strictly limited duration of the potential incarceration. Where the Commonwealth is seeking to extend the incarceration indefinitely during a pandemic, a higher standard of proof is required under principles of procedural due process.
Would this hearing also become a bail hearing?
If the judge were to determine that good cause does not exist to extend detention without bail, at that point the judge would make the bail determination.
Okay, I don't have anything else. Thank you.
Justice Gaziano.
Good morning, Mr. Levin.
Good morning.
Yeah, a few questions. So in the due process hearing, in the same question they asked the prosecutors, when is this triggered? 1 day after the time period runs, 30 days, 60 days? What's your view?
Your Honor, in terms of when due process considerations kick in, the answer is right now. There are serious due process concerns about keeping defendants who haven't been convicted of a crime locked up during the pandemic.
Even if the time period hasn't run right now?
Well, Your Honor, in terms of
someone being held since the beginning of the pandemic, they are still under the original clock. You think that's a due process crisis?
I think there is a serious due process question presented by the conditions of confinement in the county jails. Obviously, this case doesn't squarely present that issue, but yesterday the court held that the foster plaintiffs were unlikely to prove that the Department of Correction is committing an Eighth Amendment violation, but it did note that the conditions in the DOC are sufficiently dire to meet the objective prong of that Eighth Amendment analysis. And the objective prong is the only prong that's at issue for a pretrial detainee who is not constitutionally permitted to be punished at all. So obviously the constitutional, that particular constitutional issue is not squarely before the court, but
that's a huge diversion, Mr. Levin.
It's not, Your Honor. This court has to construe Section 58A in a manner that's consistent with the Constitution. And if a serious
58A has an excludable delay provision, correct?
That's right, Your Honor.
Isn't the inability of Commonwealth to proceed to trial excludable delay on steroids?
Well, Your Honor, under this court's standing order, that delay certainly is excluded from the speedy trial calculation under Rule 36. And as a result, no defendant's case will be dismissed with prejudice based on the pandemic delay. But the statutory language of Section 58A does not incorporate all periods of delay that are excluded from speedy trial calculations. There are two distinct types of exclusions under Rule 36. One is the exclusions that are specifically defined in that rule, and the other is exclusions under the common law and general principles of fairness. And the 58A statute specifically incorporates only the exclusions that are specifically defined.
So you're arguing that the COVID crisis is not excludable delay under your analysis?
The COVID crisis is not...
Can you answer my question, please?
Yes, Your Honor. The answer to the question is no. The COVID crisis is not excludable delay under Section 58A. It is only excludable delay under Rule 36 speedy trial analysis. And that is based on the plain language of the statute and the principles of lenity and constitutional avoidance.
And so if we go to intent, if it was our intent, knowing that there were people held under 58A to exclude the time in our order, is that the end of the inquiry?
Well, Your Honor, no. I think if it had been this court's intent, I think that the court would have said so much more clearly.
I can answer that really quickly, but I'll save that for later. And then you also argue that there's, don't worry if we have a domestic abuser, someone who's really, really dangerous, there's always bail. But isn't that what you told us not to do in Brandon? Because if the Commonwealth, if we're using the bail statutes the way they're intended to do, and we're only holding dangerous people under dangerousness as opposed to just giving them a gazillion-dollar bill, which used to happen. You want us to revert back to the bad old days and say, well, don't worry, just give them, they could get bail. Is that what you really mean?
Your Honor, it's clear that judges cannot consider dangerousness when setting the amount of bail, but they can, particularly in domestic violence cases, there are conditions of release that are available. But in addition, I think that a very dangerous domestic violence defendant might be a prime candidate for a finding of good cause to continue the detention. It's just that there would have to be an evidentiary hearing to prove that that good cause existed.
And you think everybody basically who's held on 58A in the Commonwealth gets one of those hearings right now?
I think everyone gets one of those hearings when the legislative timeline has expired, which is 120 days. That's
not what you said before. I asked you who gets those hearings, and you said everybody. Because I asked you specifically if it's people that where the timeline hasn't run, and you said yes. So this is different.
Well, Your Honor, I apologize for that confusion. I thought that Your Honor's question incorporated an assumption that the delay from the pandemic was excludable from that time. But assuming that the court were to construe 58A in such a way as to avoid that, then if someone has only been detained,
you would say, Mr. Levin, it's the one day after.
Yes, exactly.
Okay, thank you. That's all I have.
Justice Lougee.
Good morning, Mr. Levin. I want to start with the SXDA's position on what good cause means. There's been some suggestion in some of the briefs and our argument that good cause is sort of the conduit through which we infuse a due process analysis. But the Commonwealth's position, recognizing that there is some point where a person is held so long that there is a due process concern. We know that someone can only wait so long for a trial, even under constitutional speedy trial, and Abbott as well. But the SSDA's position, recognizing there is at some point a due process concern, has a different view as to what good cause means. They look at 58A3 and say that the individual being held shall be brought to trial as soon as reasonably possible. But in the absence of good cause, the person shall not be detained any longer than X. And that their position is, good cause means circumstances, not constitutional circumstances, where there's good cause to allow somebody to be held beyond the 120 days or the 180 days or the 90 days. And that's not the court, that's the legislature. Why is that wrong?
Your Honor, I'm not sure that is wrong exactly. The question is just, what does good cause mean at that point? And so it's really, I mean, this whole case, from my perspective, is purely a statutory construction case, and the constitutional principles are pertinent to the construction of the statute under the rule of lenity and the principle of constitutional avoidance. And so the court should construe the statutory term good cause in such a way as to minimize the risk of an erroneous deprivation of liberty.
Yeah, so I agree with the point that one of the reasons under Solano and Mendoza that preventative detention is constitutional has to do with a limited time period. And we see that AIM versus the Commonwealth was reversed because of the lack of procedural due process and substantive due process issues. I understand that. But getting to Justice Gaziano's point about day 121 or day 181, what I'm saying is that if we're dealing with statutory construction here. So we're taking into account that concern, that Solano concern, the procedural due process concern. We're looking at the statute and our recognition that the procedural due process is necessary to have this preventative detention situation, but that the statute provides that it's not 180 days or 90 days. You also have, as a matter of statute, before you touch anything constitutional, this good cause. And then their position is COVID-19 equals good cause. Now, if that's right, that doesn't mean that there's not still a due process issue at some point in time. But the Chief Justice referred to, the normal circumstances of how long somebody's held. And you look at 36 B2 and the excludable delay. And in a COVID-19 world, you're not having delay because of pretrial motions or something's under advisement or a witness isn't unavailable or a judge is making the findings necessary as it relates to the interest of justice. So what you have is you have individuals, maybe they've been held for 120 days, the motions aren't moving along, and now there's a request for a hearing based on a constitutional violation, and this individual has been held much shorter period of time than circumstances where there's not even a defense request to challenge the constitutionality of how long somebody's held under preventative detention. Long way around to say if good cause, statutory interpretation, means COVID-19, then what we're really dealing with is at what point in time are we talking about a due process violation for how long somebody's been held, recognizing that in a COVID-19 world, many of these people will be held much, much longer, much shorter period of time than an issue ever would have been raised under the statute or the Constitution.
I'm not sure I 100% followed all of that, but
let me say it much simpler. You've got people held a lot less time than you do in the normal course. You've got good cause as part of the statutory interpretation as it relates to the concern about constitutional procedural due process. And yet we're talking about 121 days being the trigger for due process. And I just am having trouble getting my head wrapped around that.
I see, Your Honor. So I guess the first thing I would say is that the court cannot ignore the overlay of what COVID-19 means for people who are locked up. And so in terms of when the due process concern kicks in, and the fact that a case based on factors that are particular to that individual case and, that a defendant is navigating the justice system in the normal world, may stretch out for a long time. That certainly is true. But under those normal circumstances, defendants are not locked up in these facilities where they are not able to protect themselves from a dangerous pandemic and where potentially they're subject to harsher conditions of confinement as the sheriffs attempt to control the pandemic. So the 120 days during the pandemic is not the same as 120 days before the pandemic started.
Okay, but that's sort of that's obviously true. And there's a recognition that we have changed circumstances with COVID-19 from from CPCS versus the Chief Justice. So that's obviously true. But isn't that sort of baked into the cake of the reconsideration that a defendant is allowed in a post-COVID-19 world, rather than being positive as to whether or not there's a due process violation?
Well, Your Honor, I think it's pertinent to this court's understanding of what the legislative term good cause means. And I think that Judge Coven was quite right to say that the legislative language contemplates a decision that is based on factors particular to an individual defendant's case, rather than systemic factors that affect everyone in the Commonwealth.
Yeah, I mean, Judge Coven makes a very good point there, but if if COVID-19 is good cause, it relates to more than 120 or more than 180 days, the specific interpretation of 36B2 as it relates to 144 is not really as important as one might think. And what really is important is, when are we dealing with due process, and when we are dealing with it, what does it look like?
So I think I agree with you that the good cause aspect of this case is the more important one. And the question really is, what does good cause mean, and how do we figure out whether there is good cause in a particular case? And I would just say that I think that this statute should be construed in such a way that the pandemic on its own does not constitute good cause, and that the good cause determination has to be made as to each defendant individually based on his dangerousness and the strength of the Commonwealth's case.
Okay. Thank you very much.
Justice Bucky.
Hi. I think you said that as a part of that good cause determination, it's your position that the Commonwealth would have to prove dangerousness beyond a reasonable doubt?
Yes.
Is that right? Okay. How would the Commonwealth go about proving that?
The factors that would be relevant to that determination are the same factors that are set forth in Section 58A.5. It's just that the judge would have to be convinced to a higher level of certainty that conditions of release would not suffice to protect the public. And I think our trial judges understand these gradations and the standard of proof.
Okay. All right. Thank you.
Justice Seifer. Justice Seifer, you may need to unmute.
I know. The security device that IT makes me put on the phone is so interfering with everything. Counsel, my question goes to, I think I have two questions. One is a more philosophical general question, and that is, in balancing all of the interests here, what, if any, weight do you give to the interests of the public and public safety?
I think that is an interest that is entitled to weight in this analysis, but I just want to point out that our system does err on the side of individual liberty, and there are only enumerated constitutional rights on one side of this balance.
Well, enumerated, but also philosophically, the whole purpose of setting up the government allegedly is to protect us from each other. So that has to be a factor in this, doesn't it?
Yes, Your Honor. I agree that it has to be a factor, and that's why I am contending that it should be open for the Commonwealth to prove that good cause exists to continue the detention of an individual defendant.
All right. That leads me to my next question. How far should we go to facilitate good, if you have a hearing, for good cause, do you have a hearing, I assume? You have a hearing?
Yes.
And sometimes witnesses?
To the extent that it's possible to safely do so, yes.
Well, that's my question, I suppose. To what extent is the defendant or your defendant or any defendant likely to be willing to waive certain things such as a confrontation right in order to facilitate that good cause hearing in these circumstances?
Well, Your Honor, I think the answer to that is that obviously that will have to be worked out on an individual basis, case by case. But if it's not possible to safely conduct an in-person evidentiary hearing, then obviously it's not possible. And so the court should provide the maximum degree of procedural protection that is possible at the time the hearing is held. And so if all that we can do is a remote hearing with a chance to cross-examine witnesses remotely, then that is going to have to be good enough if that's all that we can manage at the time that the hearing is held.
Okay, let me just ask, where in these circumstances do you think the best place for defense counsel is? With the witness in the courtroom or with the defendant? Or is everybody remote? How would you communicate with your client?
So ideally, the defendant, if possible, the defendant should be haved in. If that is not possible, then, we're sort of figuring out how to do these remote hearings on the fly, and I think different courts maybe have done slightly different things. But obviously I think some courts have sort of remote digital side rooms that a defendant and defense counsel can communicate just with each other if they need to take a pause and go into the side chat. And so that sort of thing could be worked out, I think.
Okay, thank you. I have no further questions.
Thank you, Your Honor.
Justice Kafker.
So my questions relate to the good cause. So in the ordinary circumstances, before these due process considerations kick in, we have the normal standards of proof, right, under 58A, Section 5, to prove all those things.
That's right.
Right?
Yes.
And those standards are what? Just remind me.
So the standard of proof at the initial detention hearing is probable cause to arrest and clear and convincing evidence that no conditions of release will protect the public or a named victim.
So then you say that then at a certain point in time, we have a due process overlay to this good cause analysis? Is that what we're doing? I'm just trying to make sure I understand it doctrinally and logically. So you're saying yes, that standards of proof are pushed up by the constitutional requirements, right? So
that's right.
Good cause, yeah. It's a constitutional analysis looking at the same factors that we were looking at for good cause, right?
Yeah, it's basically, if you take as your starting point, my 120 days are up, and that's the time that the legislature said was presumptively reasonable. And now the question is there good cause to continue holding me during the pandemic until it's safe to bring me to trial? At that point, you have to conduct that Matthews versus Eldridge due process balancing and figure out what procedural protections are necessary to lower the risk of erroneous deprivation of liberty.
So then we're really looking to Matthews versus Eldridge to provide the constitutional justification for increasing the burdens of proof on the Commonwealth. When we write this up, should we be applying Matthews versus Eldridge or Abbott A? What should we be applying when we do
so
that?
I think the most pertinent cases are AIM, Mendoza, and Abbott A, but particularly Mendoza, which has the really detailed discussion of exactly what the interests are that are at stake and the constitutional balancing that's required in order for the risk of erroneous deprivation of liberty to be acceptable. And so what I'm saying is that the private interest of the defendant in not being incarcerated at a time when there's a pandemic and when he can't get a speedy trial is much higher than it was when the court conducted that balancing in Mendoza. And so the procedural protections are concomitantly need to be greater.
And that may be the case. I'm just trying to understand because, I mean, the Commonwealth is saying, look, there's certain people who are dangerous, truly dangerous, and we need to be able to keep them in jail in the pre-trial, and not misuse the bail statutes to do it. So 58A is the logical spot for that. And your view is,
I agree,
that we can do this properly and we can separate out the truly dangerous from the not truly dangerous by using this Mendoza, Matthews versus Eldridge type approach. Do you think this is a workable solution and one that will work given our constraints right now, which is that we can't bring the defendant into the courtroom and we can't bring witnesses into the courtroom easily either. You think we can do all of that?
Yes, Your Honor. I think so. I think that obviously, hopefully, we're going to continue to be able to conduct more and more, procedurally protective hearings as time goes on. And if good cause initially is found on the basis, say, of grand jury minutes, then maybe that's sufficient if that is truly all that's possible when the hearing is conducted. But as soon as it does become possible to safely conduct an evidentiary hearing, then that should be required in order for the detention to continue indefinitely.
Okay, I have no further questions. Thank you, Mr. Arvin.
This is Chief Justice Gantz. You note that this is a statutory argument. So let's
Your Honor.
turn to 58A. 58A, as I understand it, says it's 120 or 180 days, excluding any period of delay as defined in Rule 36B2. So the length of those deadlines, or whatever, I know deadlines, I guess, is a loaded word, the length of those periods of time are extended if any of the excludable delay categories under 36B2 kick in, correct?
Yes, Your Honor.
Is it your view that that's unconstitutional, that anything beyond 120 or 180 days is any delay is unconstitutional and would require there to be a due process or a good cause finding?
Your Honor, I think that there's a serious question as to the length of detention that's authorized by the present version of Section 58A, given how much longer it is than the version that was considered in Mendoza. But I'm not here arguing that that provision is not constitutional so far as it is properly limited to delays that are specifically defined in Rule 36B2, which in my view only include delays that are occasioned by factors particular to an individual's case.
Well, that's my next question. So generally, of course, that's what happens in a trial. The judge would consider requests for a continuance and would decide whether or not to allow it, and would then make the findings under 36F as to whether or not the ends of justice are served. But here, the court, the SJC, said we're going to continue all cases because of the COVID crisis.
Yes, Your Honor.
Is it your view that we should have basically had each judge make findings that says, well, I can't try the damn case because the SJC has said I can't, and therefore require individualized findings by each individual judge as opposed to having the SJC make those findings for them?
Your Honor, I think it's well within this court's superintendent's power to continue all the cases and to announce that those continuances won't count against the speedy trial deadline. But whether this court's findings as to a systemic problem are findings in the record of the case, as is specifically required by Rule 36B2F, is a different question, and my contention is that they clearly aren't. And I point the court to Commonwealth versus Davis, which is the appeals court's decision from a few years ago, which held that delays that are caused by a systemic issue, in that case it was court congestion, are not excludable under Rule 36b2f in the absence of findings that are specific to a particular defendant.
But the general theme is we want these cases to be tried as soon as possible, and we're not going to use certain excuses, such as the fact that we have a lot of cases to do it. But here, we're not trying any cases right now. But what did a trial court judge do if he or she had to make that finding?
Your Honor, I don't know the answer to that, but the findings that would be made by each individual trial court judge would consider the defendant's detention as one of the relevant factors.
Well, I understand that. Although the problem, of course, is that the continuance was not ordered by the judge. The continuance was ordered by us.
Yes.
So I'm also trying to figure out then, I mean, going back to Justice Gaziano's question, we don't, as you know, well, we have a lot of cases before the pandemic hit, which were over the 120, 180 days for all the reasons which you understand. We've not said you get a due process hearing when those happen. Is it only because of the fact that being in custody is more dangerous than it was before that we should say that you should do it now, or are you sort of anticipating that the length of the SJC ordered continuance of all trials will continue into 2021 or 2022?
Your Honor, it's both. The danger of being incarcerated is very significant, and the length of the delay is not knowable. And I hope that trials will resume in the fall, but obviously that is dependent on a lot of other things, and it's far from clear that they actually will. And in light of the indefinite nature of the detention and the conditions of confinement, more is required than in order to keep holding someone.
But if the cases are to continue beyond September 8th, that's the date we've scheduled under our June order, it's going to be us who's going to do it.
Yes.
So wouldn't it be our obligation then to consider issues of due process with respect to the length of any extension and the consequence of any extension if we were to extend it beyond September 8th? Isn't that essentially on us?
Certainly, I'm sure that this court would do so, but the due process considerations of an individual defendant who has not been convicted of any crime being held without trial are individualized to each case. And in some of these cases, these guys are going to be acquitted, and they will have been subject to a wrongful deprivation of liberty, or at least an erroneous deprivation of liberty. And I think that it's incumbent on the courts to attempt to minimize those cases insofar as it's possible, and the way to do that is to subject the Commonwealth's case to meaningful testing before detention is to continue.
I have no further questions. Any questions of any of the other justices? With respect to Mr. Levin? And hearing none, Mr. Levin, thank you. And we'll turn to
Thank you very much.
Mr. Anderson on behalf of Shamus Horton.
Thank you, Your Honor. May it please the Court, Brian Anderson for Shamus Horton, and Attorney Andrew Zyberg is also with me. On January 9th, Shamus Horton was ordered held without bail for 120 days pursuant to 58A. He was then given 2 hearing dates, a pretrial conference hearing a couple weeks later on January 21st, and a bail hearing on May 4th at the expiration of the 120-day period of detention. On May 4th, the Salem Juvenile Court correctly conducted a bail hearing and set bail that ultimately resulted in Horton's release. It was the correct decision because it was an appropriate interpretation of this court's order, OE 144, but also Juvenile Court Order 620. OE 144 closed courts to the public, but delegated the authority to each court department to create its own orders to determine emergency matters and other operations. Juvenile Court Order 620 puts a juvenile-specific focus on the parameters set by OE 144. The Juvenile Court Order specifically designates any hearing required for 58A as an emergency matter to be conducted virtually. A bail hearing at the expiration of the 120-day period of detention is one of those required hearings. This is consistent with the rehabilitative purpose of juvenile court, an acknowledgement that prolonged detention is harmful to juveniles. There is a 15-day return rule in juvenile court. This emphasizes the urgency of custody cases to move them through the process towards resolution to limit detention. It also acknowledges that time spent in DYS is dead time. And I recognize that this court will address that in a currently pending case later this year. But to be clear, DYS is under no obligation to honor pretrial detention. They can consider it. There is a regulation 109 CMR 4.03 that says the history of compliance while pretrial detention can be considered in the classification process. But that is much different than the jail credit award. And in reality, DYS doesn't have any obligation to acknowledge credit. And the fact that they're opposing the juvenile court judge's decision in that case acknowledges that they don't believe they have to acknowledge jail credit. And again, my focus here is on the juvenile order and the juvenile specific issues. That's just a function of how the oral argument for these cases has been structured. The constitutional arguments raised, it just talked about by Attorney Levin, apply equally to juveniles. But for these reasons, the Salem Juvenile Court correctly conducted a bail hearing and set bail at the expiration of the juvenile's 120-day period of 50-day detention. And I'll now address questions.
Okay. Justice Link.
I don't have anything, thank you.
Justice Gaziano. No questions, Chief.
I have no questions.
Justice Budd.
I'm all set.
Justice Pfeiffer.
Nothing, thank you.
Justice Kafker.
I have one question. So, say we don't agree with you, and we believe that the COVID time is excluded, and we get into this due process analysis about how long you can the changes in the standards that Mr. Levin and I talked about a little bit. How is juvenile analyzed differently? You just said that, the constitutional arguments apply equally. Does that mean our juvenile analysis is exactly the same as our adult analysis on the constitutional standards and questions?
Well, to address the question, it's certainly not, juveniles certainly do not have any fewer protections than the adult standard. And I think that, the 15-day return rule for one provides one different example where juveniles are expected to return to court with much more frequency than an adult held for the same, in the same circumstances. I think any juvenile court decision will factor in, any juvenile court judge will consider juvenile specific circumstances. And I think this court and the Supreme Court has, started to acknowledge in the past 10 years, the brain science behind adolescent development, to recognize that kids kids should be treated differently than adults. So it's no less.
I'm trying to understand how that plays out in the dangerous analysis, because I understand when we do Dachenko, juveniles improve over time, but juveniles may be more dangerous because they don't appreciate the consequences. So I'm just trying to understand again, if you lose on your argument that the COVID delay is excluded, and we get into this constitutional analysis, is there something you can tell me about how we should adjust that discussion for juveniles? I'm just trying to make sure I understand it. And if you could even give me a couple of good examples of why it would be more favorable to juveniles and on what grounds.
So I think that I think that the 58A statute provides some framework for that, where Section 5 talks about, the factors to be considered. And I think that one specific example could be with regard to school. So a kid held in DYS is in theory going to school, but they're getting very generalized services. If a kid needs specific services because they're on an individualized education plan, it is next to impossible for DYS to accommodate that. So I think that specific circumstance is something that could be raised at a subsequent hearing after the initial 58A determination, that it's brought to the attention of the juvenile court judge that you've made this dangerousness finding, but now there's a specific circumstance that this juvenile has. He cannot get the educational services he needs in DYS. He has to be let out so that he can go to a specialized school to get specialized instruction. And in my experience, that's something that happens, very, very common.
Okay. I think that's helpful. Thank you very much.
And I have no further questions. Are there any questions of the justices in response to Justice Kafker's questions? And hearing none, thank you, Mr. Anderson. And we'll turn now to Mr. Schneiderman on behalf of Mr. Smith.
Good morning. May it please the court. I am Joseph Schneiderman. I represent Scott Smith. The Commonwealth has asked for a process for what happens at the end of a bail revocation, but for three broad reasons, their proposed process is not sound. First, Section 58B cannot be rewritten to embody any equitable tolling, which the Commonwealth forfeited by not raising at any time to Judge Tyne or to the single justice. Assuming this court decides that the Commonwealth has overcome forfeiture, Section 58B sets an exception to the rule of bail and indeed places the onus on the defendant to overcome a rebuttable presumption that no set of conditions will secure the safety of the public, and there is no reopening of a bail revocation except for a manifest injustice. The Commonwealth has not addressed that. The Commonwealth is asserting that someone's past danger, which there is no question in the record that Mr. Smith has an extremely troubling record, suffices in and of itself to detain. That premise can't be correct. That premise potentially places Section 58B into constitutional doubt. Second, good cause truly requires proof of extraordinary circumstances and must be narrowly tailored to respect a defendant's liberty interests. Concretely, good cause should be evidence that the defendant will thwart the prosecution by intimidating a witness or destroying evidence or something along those lines. That standard is not only narrowly tailored, but it is harmonious with how bail revocations may not be reopened except for manifest injustice, and it avoids some of the concerns which the Chief Justice and Justice Lougee articulated in the district court, which is that a defendant may be held for effectively all of his time that he otherwise might have served. Indeed, this is not in the brief, but the district court cannot sentence someone to state prison. So any sentence is going to have to be a house of correction sentence, and house of correction sentences are regulated by law. Finally, the Commonwealth's proposal, relying on Abbott A, is not narrowly tailored because there are no definite backstops. Preliminarily, Abbott A is completely distinguishable because competency would operate as a toll whether one's bail is revoked under Section 58B or whether one is held as dangerous under Section 58A. That is what this court said in Abbott A at page 37 of the decision. The judge was required to hold someone. Competency also implicates a right not to be tried, and that is why there are those backstops such as a 16F dismissal in the interest of justice or a 17B hearing to present evidence. The fluid framework places this into constitutional doubt. As my esteemed brothers have mentioned before, the court has to err on the side of liberty, particularly where there is a rebuttable presumption that the defendant's offense, which I note here, the defendant is charged with a comparatively minor drug offense, that no conditions of release assure the safety of the public. The Commonwealth also asserts that there will be forced releases. I think that is an overstatement. The defendant's right is to seek release at on day 91 or day 121 or day 181. And indeed, Pagan makes clear that the defendant has a right to a bail hearing. We urge that this court adopt a more specific framework with concrete deadlines, such as a right to review every 30 days. I welcome questions.
Justice Link.
Yes. Good morning. Now, I want to get back to what it is that you mean by good cause. You seem to be making it a very narrow meaning to good cause, such that what the Commonwealth must prove is somehow different than what it must prove under 58A for dangerousness. Is that not so?
Your Honor, I apologize if I was suggesting that good cause has to be narrow. I was offering a concrete definition of what good cause is, but good cause in the bigger picture should be narrowly tailored to respect the defendant's liberty interest, and that's why I suggested it is circumstances that are unique or extraordinary.
So would your answer suggest it's different?
I beg your pardon, Your Honor? I'm sorry.
I'm sorry. So your answer is yes, the good cause is different than what needs to be proven in the first instance in terms of dangerousness under 58A? It's different?
Yes, Your Honor. Yes, as I understand Your Honor's question as to is there a difference between the calculus at an initial detention as opposed to continuing a detention?
Yeah, and I'm not talking about the difference in standard in terms of clear and convincing evidence or beyond a reasonable doubt. I'm talking about the content. What it is that they come with us to prove. Is it different?
I think it is different, Your Honor, because the Commonwealth has already had an opportunity to show that someone is dangerous, and in the context of 58B, the defendant is the one who has to show that there are conditions that will assure the safety of the public because of the broad rebuttable presumption in 58B.
Okay. I don't have anything else. Thank you.
Thank you, Your Honor.
Justice Gaziano.
I have no questions. Thank you.
Justice Lougee.
Thank you. Mr. Schneiderman, I want to ask you some of the same questions I asked Mr. Levin in response to your comment about good cause. So, 58B, like 58A, provides a period somebody can be held and it can't exceed 90 days on the revocation in the absence of good cause. That's the statute. Now, I'm not sure that I read that in any of our cases or in the plain meaning of the statute that good cause means unique or extraordinary circumstances. But it seems to me that COVID-19 is unique and extraordinary. So I have no doubt, I don't know how one could, that there isn't a point in time where somebody's being held and there's a due process violation. That COVID-19, hopefully this is never going to happen, is going to go on, and there's a point in time where there's a constitutional violation because someone's being held and there's no prospect of a trial. Thank goodness we're not there. I hope we never get there. But there's no doubt there's a due process point. But when you say day 91, or you say, or 121, or 181, I want to make the same point I made to Mr. Levin, is we have people all the time held way more than that. And the difference is that in 36B2, in the normal course, there's excludable delay as the case proceeds through the process. Now, I want to take it as a given that the COVID-19 and the circumstances that the defendant is in prison in is a factor in this due process totality of the circumstances. But what I'm having trouble understanding is in a normal course, someone's held way beyond 91 days on a revocation or on a 58A, and you're arguing it's a due process violation on day 91, and I want my due process here. I'm having a hard time understanding.
Your Honor, if I follow your question, I agree with Your Honor that COVID is an inherently an extraordinary circumstance. What I am suggesting, and I apologize if this was not clear, is day 91 or day 121 or day 181 triggers the initial right to seek relief at that point. And I think on a practical level, a district court judge should be solicitous of the fact that this timeline has expired under the statute. And indeed, as this court recognized in Pagan, a bail
That's the question. That's the question. Hold on. That's the question. Has it expired under the statute when the statute doesn't say 90 days, 120 days, or 180 days? It says, in the absence of good cause, a person so held shall not be detained for a period exceeding those particular days. So it's not on its face violative of the statute. Nor is this person being held anywhere near as long, if they've really been arraigned in the COVID-19 world, than in the normal course. And again, I recognize that when you're in jail or in the, prison in a COVID-19 world, that's a lot different. And I say that goes into the due process analysis. I understand. If there's no prospect of a trial soon, I understand. But I'm having a hard time understanding how it's day 91. You know, in last year, someone was held for a year and a half before their trial. There was not even a motion for a due process violation. And here, the argument is on day 121 or 181, we have that. When the statute doesn't even provide for that. The statute provides in the absence of good cause, and I'm having a hard time understanding why COVID-19 isn't good cause. Not dispositive, but isn't good cause. Do you understand my question?
I believe so, Your Honor. And if at any point in my answer I'm not answering, please redirect me. I agree with Your Honor that the violation is not right on day 91, if I follow and understand Your Honor's point. But the calculus or relying on that fact alone, which I think Your Honor and I agree on, is not the only fact that justifies further detention, is problematic, particularly where there's not play between the defendant's interests and the Commonwealth's interests. Put another way, and put perhaps a bit more simply, COVID in and of itself may be good cause, but COVID would be overburdened in the analysis if that's all the Commonwealth is asserting, which is why I suggested more concrete evidence of what to look at.
Okay, thank you very much.
Justice Budd.
Thank you, Your Honor.
Hi, I have no questions.
Justice Safer.
I have no questions.
Justice Kafker.
No questions.
And I have no questions. So are there any other questions of the justices of Mr. Schneiderman? And hearing none, I thank you, Mr. Schneiderman. I thank all the attorneys, both for their advocacy as well as for their written briefs. And this will conclude our hearing. For the justices, we shall commence our ensemble at 12:30 on the separate line, which each of you have. Thanks so much.
Now exit.